Hi, Sarah Jacobs here. Thank you for joining me today as I highlight issues surrounding supervised visitation or supervised parenting time, as it's called in New Jersey. It's really important to understand that supervised parenting time doesn't just happen in cases where there are allegations of abuse and neglect or DCPP is involved. Supervised parenting time can take place in parenting time negotiations and agreements with two parents, especially if there are concerns about a child's safety. First, let's talk about exactly what supervised visitation or supervised parenting time really is. This is actually one of those rare instances where the words actually match the exact description of what the outcome is. Supervised parenting time or supervised visitation is when a parent or a caregiver and a child enjoys parenting time, but is monitored by an independent third party to make sure that the child's emotional, physical, or mental safety, or a combination of all of those, is protected. Second, it's crucial to understand that if parents can't agree to implement supervised parenting time, the party who's seeking it has to make an application to the court. While the court's goal is always to protect the best interest of the children and will enter an order if it finds that the circumstances warrant it, it's the responsibility of the parent making the application to prove that there are reasons why supervised parenting time must be implemented. Simply making allegations that supervised parenting time is necessary isn't going to support your claim. Your application is better supported when you're able to present some of these type of circumstances. Your co-parent has a mental illness which impairs their caretaking for your children. Your co-parent suffers from a drug or alcohol addiction and has acted erratically or dangerously in front of your child. Your co-parent is dangerously driving with your child in the car and has gotten DUIs or DUIs. Even though these circumstances are very black and white, facts matter. It's important that you present these facts to the court when you're asking it to impose supervision. Conversely, a parent facing a supervision application may be able to prove to the court that A, it shouldn't be ordered, or B, that there should be certain rules or restrictions put in place on how and when they're supervised. There are also options for step downs or tiers when it comes to supervised parenting time. You can put in certain self-actualizing markers so that when obligations are met or things are completed, you don't have to return to the court over and over in order to begin to lift pieces of the supervision. This is why it's incredibly important to work with experienced family law attorneys who understand the nuance of custody and parenting time and supervision, and who can help you be creative when you're trying to defeat an application like this. When contemplating whether supervised parenting time is right for your arrangement, it's really important to understand how this can be carried out. Often, it's neutral third parties, which can include family members, appointed court individuals, or contracted companies who specialize in supervised parenting time. It is possible for the other co-parent to supervise parenting time, but this is usually only implemented when there are really young children, newborns, or nursing infants. It's important to understand that when one parent is supervising the other, there can be allegations of unfairness, there can be increased acrimony, and it's a very special situation where both parents are involved. If you're concerned about your child's safety and you're contemplating an application for supervision, or if you've been served with an application for supervised parenting time and you don't know what to do, we can help. It's important to talk to an experienced attorney, but one who can help keep your child's safety at the forefront. We look forward to talking with you.